What a long, strange ride this has been. You heard it first on KPL yesterday. You saw it on the news last night on our news partners at KATC. The article in the paper this morning by Claire Taylor. My goodness. And the gentleman who's been right there every step of the way on the journey is on our Delta World Tire hotline, Mr. Gary McGoffin. Gary, welcome to the Ross Report again.
Well, thank you, Carol.
Same topic, different day.
Yeah. Fortunately, we got a little bit of something different to talk about this time.
Oh, my gosh. Yes. I want you to maybe just give the audience a brief summary of how this all started, because there are some people maybe, who don't know exactly how this all started. So let's give them the background and your involvement.
It wouldn't be unusual for people not to know how it started because it's been well over 2 years since it started.
Wow.
I represented the Independent Weekly at the time, and still do. Marshal Pope had a very peculiar press conference on October 7th, 2015, in which he claimed that Lafayette was overrun by illegal Hispanic lawbreakers who were being sheltered by then Marshal or then Sheriff Newstrom and candidate for Sheriff Mark Garber. Mr. Pope was supporting Mr. Garber's opposition. He held a press conference, and it was very peculiar in the way it was constructed. And the Independent sent a public records request the next day requesting emails related to the press conference with specific search terms that would have disclosed who the author of it was, that sort of thing. Over a long period of time, the Marshal refused to present the documents. We had a hearing on December 14th after we filed suit, and he testified at that hearing that no such documents existed. The judge was not convinced that he knew what he was doing in doing a search of his own computer for emails, and so suggested that the Marshal retain an IT expert and that they produce whatever the IT expert found within 3 days of that hearing. 3 days later, I had 588 pages that had been printed off of the computer, but none of them had the emails that we were looking for. We really believed at that time, after looking at it, that the press conference, the press release, and everything had been coordinated and scripted by the campaign manager for Chad Leger, who was running for sheriff at that time. We pursued that, and over a period of time, we had a hearing on December 14th. We had a follow-up hearing on January the 4th, and in the middle of that, we took Marshal Pope's deposition because he was going to be out of town on January 4th. Before the deposition, which was on December 28th, the Monday after Christmas, we had obtained documents from Lafayette Consolidated Government, who ran the backup server for the Marshal's office. And they produced those documents to us, strangely enough, on Christmas Eve. Christmas morning, I was literally at my office opening Christmas presents because it had all of the documents that had been traded back and forth between Joe Castillo, who was the campaign manager, and Marshal Pope. And it was all the documents we looked for in terms of scripting the press release, scripting the press notice, scripting the press conference, scripting the handout, scripting the talking points for the Bernadette Lee radio show that followed, etc. So we went to
Let me ask you this, Gary, though. At this
Sure.
point, if he had just turned over all of that, there might have been some ethical violation, but nothing to where we are today, right? I mean, if he had just turned over...
No. If he had, here's his problem. If he had simply responded and said, here's the stuff, he may have had an ethics problem. It would have been finished in 2015. We would not be where we are today, and he would not be where he is today.
Yeah. Okay, so continue. I didn't mean to interrupt, but just...
Sure. Good point, because I could really go on about this, so let's break it up. And what happened on January 4th is the judge was convinced that Marshal Pope had not honored the orders he had been given on December 14th, which was by mandamus and by injunction, not to withhold the records and to produce the records. And in fact, what we proved at the March 22 hearing on contempt was that the Marshal had actually destroyed the records, or at least attempted to. Fortunately, LCG had the backup documents. So he was convicted of criminal contempt on March 24th. He appealed to the Third Circuit, to the Supreme Court.
Now, by now we're into 2016, right?
Yes, ma'am.
Okay. All right.
And remarkably, we got through the Third Circuit Court of Appeal and the Supreme Court in 2016, which is breakneck speed in the legal world.
Oh, truly.
Traveling at warp speed. And each step of the way, the courts of appeal upheld what Judge Edwards had found. So, hang on just a second. I got to take a drink of water.
Yeah, that's okay. Go ahead. Yeah, this is a long story. I mean, can you imagine that back in October 7th, 2015? Good Lord, over two years ago.
28 months.
Wow. All right.
So what happened was the judge held him in contempt, and interestingly, I found out, I'm a civil attorney, I don't do criminal work, I found out you can have criminal contempt in a civil proceeding. And what that means is you cannot purge yourself of the contempt by complying with a court order. He was being punished for not complying with the court order. And two things were ordered. One was 30 days incarceration, and the other was 173 hours of community service. The appeal was exhausted in November of 2016, and in March of 2017, we requested a status conference or hearing to determine if he'd done any of his community service, and he had not. The judge heard the evidence in March. In September, he issued a new order, or a modifying order, saying, I don't think you can do the community service I ordered, which was making public record presentations to public bodies, officials, that sort of thing, talking about the importance of public records and what the ramifications are to the public and to the custodian if they don't honor their obligations.
Okay, now that September hearing, was that the one that the previous weekend he went out and picks up some, or no, it was after that, right? After that
was December.
Okay, all right.
but you're on the right track.
Okay.
So he was given
I'm trying to make notes here, Gary. I'm telling you. It's just, I'm running out of paper.
I understand.
All right, go ahead.
So in September, the judge issued an order saying, okay, you got a choice. You can either do the public records presentations or you can do litter abatement. Your choice, either one. So that was in September of
2017, right?
2017.
Right.
Right. I'm getting lost as well. So that was in September, and it was not until we filed a motion in December or for a December hearing, again, to follow up on the status of a public records request. I'm sorry, the
probation
service.
Yeah.
And we actually requested the probation be revoked for his failure to perform. We had the hearing in December, and it was on December 1st that he registered for his first day of litter abatement. He chose that option. You can only do litter abatement once a month in Lafayette Parish, supervised by the Misdemeanor Probation Supervision Office. And so he did go out on, I think it was December 17th, and picked up litter for the first time. And we've checked the records, and he did again in January and February. So of the 173 hours, he actually did 24 hours of community service.
Wow.
And that was it.
Wow.
Until we had the hearing, which we went to, what was it, yesterday?
Yes.
Man, this thing gets confusing.
Let me tell you something. But in the interim, wasn't there another hearing that was postponed by his attorneys, I believe, where the judge got pretty frustrated? I mean, Judge Edwards has been pretty frustrated by this, where he said, you still haven't admitted any fault, and now you've only done that one day. At that time, it was 1 day of community service.
Correct. That was the December hearing.
Okay, yeah.
And in that hearing, it was interesting because, again, I don't do criminal work, so I'm not familiar with this, but the judge referred to a concept of restorative justice. And he had Marshal Pope stand up in court and explain what that meant. And there's three parts to it. The first is, and keep in mind, Marshal Pope had exhausted his appeal through the Supreme Court.
Yeah.
So he stood convicted of criminal contempt when he was standing there in December of last year. And the judge said there's three components to restorative justice. The first is you have to admit to yourself and to others that what you did was wrong. The second, it's kind of like the old mess up, fess up thing we learned.
Right.
All right, first you got to admit that. Then you have to admit who you have hurt by your wrong and what that harm was. And third, what steps you've taken to rectify that wrong. Another part of that hearing was we had attempted to revoke his probation. And procedurally, it gets very confusing because we've got criminal contempt in a civil proceeding. So who has the right to seek a revocation of probation? The district attorney was not involved in our case, but it's criminal contempt. Judge Edwards decided he was going to refer it to the district attorney, just out of an abundance of caution. Mm-hmm. But the district attorney declined to become involved because it was a civil case, still is a civil case. And I think it was prudent because intended to discuss things that we thought Marshal Pope had done wrong during the course of his probation. Mm-hmm. And I think it was prudent for the district attorney to be cautious about making sure that the 23 days remaining on the imprisonment wouldn't be imposed and then constitute double jeopardy on a criminal conviction or prosecution
on the felony felony perjury. That's a separate issue from this, correct?
We were going to bring up additional acts that he had committed.
Okay.
For instance, arresting Stephen Wilkerson, co-chairman of the recall effort, things like that.
Yes.
So the DA declined to prosecute or become involved. It wasn't their case. I think it was appropriate. So we filed a motion to dismiss our motion to revoke the probation and instead requested a hearing on the status of the probation. And that's the hearing that we had yesterday.
Yeah.
And so
I tell you, I think
showed up and literally.
Go ahead.
Judge Edwards did everything. He was prepared, and he was even-handed. He was frustrated. The attorney who spoke for Marshal Pope yesterday, Marshal Pope never spoke. His attorney spoke and talked about their good faith, trying to get this done, the difficulty, and doing the community service because of limited time and difficulty and that sort of thing. And that they needed more time until November to finish. The judge said, I don't think it's possible for you to finish by November. And so he revoked the probation.
What was amazing to me is, I kind of got, I really felt some empathy for Judge Edwards because it was almost like, how many times do we have to have you in court to get you to do the right thing? I mean, the last time I think he said something about, can't you even admit your fault here? And that you wouldn't even go that far as to do that. And then the attorneys said, well, we reached out to the University of Louisiana, UL Lafayette, and the City Marshals Association about speaking on on public records. And the judge said, what? That's where we started this. This is where we all started.
And Pope's attorney in March of last year, when we went in the first time on what was going on, made the same points about contacting the same people. And Marshal Pope had done none of that in the intervening year.
Yeah. So the judge, you could see, you could hear the frustration. He's a new attorney. That's what I said. How many attorneys has he had now, and who's paying for them?
Correct. And that's a good question. I have a public records request into the Marshal's office now asking for the contracts, invoices, and payments to attorneys.
Wow. Well,
he's not responded yet.
No surprise there. And as the judge would say, this is what you call good faith. But Gary, really, this is very troubling for the people of Lafayette, and other law enforcement people have to be really scratching their heads, including the sheriff that they went after in the first place, Sheriff Garber, because this doesn't reflect well on law enforcement at all. How do you think his office is running? Have you had any indications as to how the Marshal's office is running with all of this turmoil?
Only anecdotally. I'm told they're doing a good job. The office is running efficiently. There are good men and women in that office who are doing the best they can.
Yes.
It's got to be an embarrassment to them. I've had law enforcement professionals come up to me informally and tell me how embarrassed they are, and also thank you for exposing it.
Yes. I can only imagine how frustrating it is for them. We have all of this going on with the shooting in Florida, to compound this, because everybody's questioning where was law enforcement in that issue. And then we have the Marshal here, this as you say, over 2 years, 28 months of this going on, of thumbing his nose at the law, which he is sworn to uphold. And And it just has people scratching their heads in it. And I know that there are a lot of good people over there. I think Nikki Picard set up a heck of an office over there and did a great job. And I know that there are a lot of people in there who are doing a great job. But this has to be very upsetting for them, truly.
I have to agree with you, just as it is to the good folks of this community.
Yes.
How is it that the chief law enforcement officer of our Lafayette City Court is breaking the law?
Wow. Yeah, that doesn't engender confidence or a willingness to comply with the law when you have one of the top law enforcement people in the city court. How do you see this going forward? I mean, this is just one part of it, the 23 days that he's going to spend in jail. But going forward, he still has some felony perjury.
Yes, he has 7 felony charges. 2 are perjury and 5 are for malfeasance. They're scheduled presently for trial on April 23rd here in Lafayette. There are motions that have been filed and will be heard on March 26th, attempting to change the venue, saying that the news coverage here has been so pervasive that the marshal cannot receive a fair trial in Lafayette. Also seeking to quash by quash I mean rule inadmissible, the emails that we found that showed that he had been in communication and what he had done in uncovering other wrongdoing in his office. For instance, using his office to send out a political fundraiser mailer. That's one of the charges he has for malfeasance. His office staff prepared it.
Wow.
He was proud he'd paid for the stamps.
Oh, my gosh.
But when I asked him, and this is all on video deposition, this isn't speculation. I mean, this is TV.
This is under oath, video deposition. Under oath.
That's correct.
Okay.
So, for instance, they're trying to say that those emails are not, shouldn't be admitted because they were illegally provided to us by Lafayette Consolidated Government.
How is that possible? Lafayette Consolidated Government does contribute to the running of that office, does it not?
Well, it managed the backup archive, the Barracuda server, is what it's called, which had all the emails from the marshal's office. The marshal knew all of his backup emails were at Lafayette Consolidated Government. He attempted to delete those emails and thought he had from his computer.
Yes.
And he did, apparently, from his computer. But his backup service had that. So we sent a public records request to them. They produced it on Christmas Eve. And now he's saying the district attorney should not be able to use those emails, but the district attorney had nothing to do with obtaining them.
Yes.
We introduced those emails
That's
in the
part
video.
In the civil case.
The hearing, in the civil case on January 4th, and again on March 22nd in the contempt hearing. So those are all in the civil record. They're in the public record already. And when that was concluded and they were in the civil record, I sent copies of that to the district attorney saying, you might want to take a look at this. And they did. So I'm not sure how he gets to quash those documents because the district attorney did nothing to obtain them from LCG. They simply received them.
Yeah. Okay, so now when it goes back into court, will it go back into Jules Edwards' court again or in a different court?
No, the criminal prosecution is in Judge David Smith's court.
Okay, all right.
Judge Edwards has the public records case, and with any luck, we're finished with that.
Okay. I bet you're hoping you're finished with that.
It's time to move on.
Well, and do you think they have a chance? It does seem that there's been a lot of coverage, including on this radio station, TV station. I mean, really, I don't know how people haven't kept up with this, but do you think they have a chance to get a change of venue?
Well, let's first say that I don't do criminal law. So I've done some research on this just out of my own curiosity about what is required for a change of venue. And there are several factors that are considered. One of the principal ones is prosecutorial
misconduct.
Misconduct, which they get on the radio and say, this is a bad man, he needs to be convicted, that sort of thing.
Right.
But none of that's happened.
No.
And has the coverage been so inflammatory that the community cannot render a decision in a case based upon the evidence? Well, our news media has done a pretty good job of presenting the facts and letting our community make up their mind for themselves.
I think the coverage is more perplexed than anything else. What the heck?
Right. Now, but give you one of the cases that I checked. It's the Louisiana Supreme Court case on change of venue for Derek Lee. They remember Derek Lee in 2008. Well, actually before that, was convicted of being the serial killer in Baton Rouge. He did not get a change of venue in Baton Rouge.
Wow.
I tend to think that, as appalled as anyone might be about what Marshal Pope has done, it doesn't rise to that level. So I think as a practical matter, from the case law I've seen, it appears that they'll may have the hearing on the 26th, and some of the cases have said they can wait, take it under consideration, take it under advisement, wait until after attempting to seat a jury. If they're unable to find an unbiased jury, then they can determine whether it should be a change of venue and where to. But if they're able to seat a jury, then they move on.
All right, so you and Judge Edwards, you're out of this now, huh? Is that right?
Luck.
With any luck. All right, Gary, thank you so much for your time and laying it out. And oh, my goodness, what a long, strange ride it has been. Hopefully for you all it's over. And for the community, I hope it's over very soon. Thank you so much, Gary. We appreciate
Carol, thank you.
We appreciate you very much. Thanks.
Thanks.
Okay, people, there you have it. That's the A to Z. Oh, my gosh.